may call the next case, please.
Rachel Poyner Hight versus Billy Hugh Hight.
May it please the court, I'm Mary Jo Middlebrooks of the Jackson-Madison County Bar Association, representing the appellant. Lisa Houston, also of the same bar, is representing the appellee. I would ask you to reserve 2 minutes for my rebuttal.
2 minutes.
Yes, sir.
All right.
In this case, we have 2 children, Hayden, who is 15, and William, who is 11. It is a relocation case, which came with it a request for modification. Our first and I guess, our major issue in this case is whether the trial judge erred in separating the siblings. In this case, my client is a doctor. She is an anesthesiologist, and I would like to correct one thing in the appellee's brief concerning her quitting her job. She actually submitted her resignation due to the fact that what was going on at our hospital caused her to be concerned because they were unable to meet the standard of care. You will find her discussion about that in her testimony, and it was very frightening, frankly, to hear about it, and it got worse after she left. And so she had no choice, in her opinion, but to resign. Then she had to start looking for a job, of which there are no other jobs in this area for an anesthesiologist. And she had already had looked in Alabama and Nashville and others that had large medical communities. And fortunately, after it was almost a year, she just happened to get a phone call and said, "We need you to come over and be the supervising anesthesiologist at the Le Bonheur Pediatric Surgery Center." And what this meant was that she would be there starting at 7 o'clock and would be able to leave around 3:30 or 4. It was an excellent job with excellent benefits all the way around. The only problem was, of course, living in Jackson, she had to get up at 5 o'clock in the morning to be there at 7 and hope that it wasn't going to be snowing or the traffic causing her not to be able to get there in time, because they could not start any of the surgeries until she was in the building. Now, they also had 2 backup doctors, so everything was worked out, but it was quite grueling. And one of the things that the appellant's brief complains about was that mom would no longer let dad have the children in the morning to get their breakfast and get them to school, as they had done previously when she was already at work. The only problem is he wanted to pick them up at 5 o'clock in the morning, and they don't usually get up until 6:45 to go to school. And his idea was wake them up at 5 and come over to my house. So that's not the same as saying, she wouldn't let him see the children in the morning anymore. It was not in the children's best interest. So there were problems that started once the lawsuit got started. But generally, though, these 2 parents worked together very well and could continue to do so. But dad did not want mom to move to Memphis and change how they've been doing things. So where we're left with this in this case is that we submitted our proposed plan, dad submitted his proposed plan, and the chancellor instead decided to split the children. No one in any pleading, in any testimony, in anything presented to this court, to the chancellor, asked for the children to be separated. And there is no factual reason for the children to be separated. And so our problem is that we don't think it's in the children's best interest as siblings to be separated. The chancellor offhandedly said, well, they're only going to be together 3 more years. She'll be off to college. And I immediately thought, well, that's a compelling reason to keep them together. They need their time together as children. And we do not think it's in the best interest of either child for the siblings to be, for them to be separated in this case. And we have
Are you saying the chancellor erred in his factual findings or in his application of the law?
Well, the second issue does address our question about the law, but I think obviously the chancellor is able to separate them because other chancellors have. We're just saying in this case, it's not in the best interest of the children, but in my second one, just...
Well, stay with me a minute.
All right.
Are you saying that he incorrectly found some of the best interest factors one way or the other, that he didn't analyze the facts correctly? I'm just trying to figure out where you're going with this. I understand you don't like it, but I'm trying to figure out what the basis is of your disagreement.
Not only not liked it, but I was shocked when it happened. Again, because it was never pled at all.
Does that mean he can't do it?
It means that that was not before the court. How, as a trial lawyer, could either Ms. Houston or I prepare to put on any proof about whether it was in the best interest of these children to split them up when no one asked for that? No one asked for that.
Do you have to ask for that, though? Isn't it within the province of the trier of fact when you put the issue of what's in the best interest of the children for him, her, whoever it may be, to make that decision?
I can't point you to any case law that says that. I think that there are very few that deal with separating of children, and generally that separation occurs because of what is referred to as a drastic remedy. And that's why it's called a drastic remedy, with extraordinary facts that require it. So my answer to your question is, I don't think there are any facts that support this as an extraordinary fact that requires these 2 children to be separated. And as a matter of law, I think he ruled on an action that was never pled at all. And it doesn't appear in the record anywhere by testimony, by pleading, or anything. And for that reason, I think there was an error, both in fact and in law.
Did he give any factual or legal basis to support that decision?
No legal basis, but his factual basis seemed to be mostly because Dad wanted to have extracurricular sports with his son. Now, he did go into, how this child, and I would not benefit from the school that mother was going to send the children to, like the daughter would. I don't know that that's true. If you see Exhibit 1, I think also that in the appellee's brief, it says that mother had not decided on the chosen school, but she said she wanted Dad to have an input, and we put in as Exhibit 1, which what you got is not what we put in, by the way. They photocopied everything, so it's hard to see it. We had the actual folders and all of that. When I saw it, I went, oh my gosh, this looks terrible. But in any event, it's Briarcrest, which is supposed to be one of the best schools in Memphis, and both children would be able to excel there. So, you know, she did choose a school, but she was going to allow Dad to also, as a teacher and as a father, to try to have some input into that. Did that answer your question, Judge Golden?
Well, I was really just trying to find out whether or not the court supported its decision as to why it separated the children.
Well, I think the only reason is because Dad wanted to have his son do extracurricular sports together. Apparently, Dad had an early injury and all he could play was tennis as a young man, and so he's into all of this extracurricular stuff with his son, which is great, but I don't think it rises to an extraordinary reason to keep that child separated from his sister.
Ms. Meadowbrooks, forgive me, my voice is going.
Well, I think mine's going too.
Did the court not make some findings about the different needs of the children educationally? Maybe the older child had some issues in school that the younger child had not had?
Yes, and that's why I said there was a difference between what both of the children would need. But Briarcrest was not chosen because of anything that Hayden needed. She had been bullied at school, and Briarcrest apparently has theater programs and all sorts of things that she really likes. They also have everything that the younger child, William, likes. So it wasn't that she had anything where a special needs child or anything like that.
Thank you.
If you don't have any other questions about separating the siblings, I think we have talked about sufficiently, unless you have any other questions about the issue about whether the chancellor should have split them without anyone pleading that or requesting it in court. So I am down to, at this point, just the question about the attorney fees. And the court awarded him half of his fees to be paid by Mother, even though he did not prevail. So we would ask you to reverse on that, and my client is asking for an award of attorney fees in this cause.
Do you have to be the prevailing party to recover attorney's fees
Yes, sir.
under the statute?
Under the case law,
I'm talking about the statute.
the statute does not say that specifically. Thank you.
Thank you.
Okay. Your Honor, my name's Lisa Houston. As stated before, I represent the appellee, Billy Hight, and we're here on a relocation case. And so I do want to address the issues that were brought up by the court and by Ms. Middlebrooks. The first thing that I would like...
Please speak into the mic.
Yes, it was vibrating back here, but the first thing that was mentioned is the cause for Ms. Hight resigning. We dispute that. There was a relationship. I think that's a factual issue that's not necessarily relevant as to the case law itself. As it relates to the modification and notice in the pleadings, the modification, the relocation statute in and of itself provides that the court will do a modification of a parenting plan if one parent relocates. In this particular case, it had two alternatives. If she does not relocate, which she has not yet, if she does not relocate, the parenting plan that's in place will remain in effect. If she does relocate, then we have the separation of the children. Now, as to relate to the separation of the children, there were reasons beyond sports as to why the judge separated the children. He literally looked in and said, we're dealing with two different children with two different personalities. Some of the things that he said was the eldest child, who is 16, she was 15 at that time, in 11th grade, at 10th grade at that time, had anxiety issues, more difficulty in making friends, and experienced high school bullying. The youngest child, who is currently 11, he was 10 at the time, in 6th grade, 5th grade at the time, is outgoing, developed a wider circle of friendships with common interests and indoor activities.
Did the children testify?
Excuse me?
Did the children testify?
The eldest child testified, and it is in the record. And she did state, I will like to state that she stated that she wanted to move with her mom, but she liked living in her childhood home, which would have changed had she moved. And she doesn't necessarily not like her dad. It's just kind of, she has more in common with mom. As far as, and that's specifically stated, one of the other things is the court had stated was it provides a fresh start. She's more like-minded interests with the mother. She has different interests than her brother. She is involved in art, choir, theater, and no longer participates in sports. That was what the court stated as it relates to the eldest. The youngest, he said, however, the relocation is not an enhanced benefit to him. William, to be more socially integrated in his young life, it would impact his relationship with his father, who taught at the same school and is teaching him in this middle school as we speak, and potentially traumatic to remove him from a familiar and comfortable environment wherein he's doing well. Father and William have a very close bond, same school, close-knit friend group, been at USJ his entire school years. Father has been actively involved with the children. Both children are excelling, both academically and doing well, and involved in extracurricular activities at USJ at this time. So he did address, he didn't do an overall best interest, he did a best interest for each child. And based on that, we would state that the case law provides that although it's a dramatic decision to separate them, it's something that you look at the best interest of each child. And so that's what the court did. It reviewed the facts for each one.
Did the trial court come up with the separation on its own, or was it suggested by the parties, or how did this come into being?
The trial court did come up on its own, but I will state that one of the issues that she had brought up was that he can't modify beyond the realm of that. And I think the statute, the relocation statute in and of itself provides that he has the ability to modify a permanent parenting plan. And in TCA 366101A2A1 states, quote, "The court shall have the widest discretion in order to order a custody arrangement that is in the best interest of the child." In 366106A states, "Any other proceeding requiring the court to make a custody determination regarding a minor child, the determination shall be made on the best interest of the child." In the relocation statute under the 2018 version, it states that the court shall modify the permanent parenting plan as needed, enter a modified parenting plan that shall become effective only if the parent proposing to relocate does so. So he's had the ability, statute provides the ability to do the parenting plan, and he's the decider of fact. And it was an all-day trial. He had several pieces of fact, and we state that he did not abuse his discretion. And I'm aware that there is a presumption that of correctness for that. And so I looked through as it relates to the abuse of discretion, and which would require this court to consider whether the decision has sufficient evidentiary foundation. I think the record and the appellee brief speaks to that, and there was. Whether the court correctly identified and properly applied the appropriate legal principles. That was the relocation statute. He went through that. It was like it was given a roadmap and he was doing Google Maps. He went through it, every single subsection. And then he even addressed the 106 factors. Then the next question is whether the decision is with the range of acceptable alternatives. In this particular case, it is. We have two children that if the mother decides to relocate, the eldest daughter will go with her, who's like-minded, and will hopefully excel. My client didn't want either of them to move. He thinks that moving her to a new environment in her 11th grade with anxiety issues would have a negative impact. So he didn't necessarily want it, but he took what the court had, which leads us to, we would state the court did not abuse its discretion in this case. Then I would go to attorney's fees. As it relates to the
You're not
attorney.
raising an issue as to what the trial court did, are you? You're not also appealing the separation,
No, Your Honor.
even though your client did not believe it was the appropriate thing to do at the time.
He is not. As a parent, we have to decide whether or not going against a 16-year-old and 11th grader is going to be more traumatic than not. We've dealt with family law, and many times they can disrupt the family life because they don't get their way. And she had specifically stated to the judge that she did want to move with her mom if mom moved. And so, no, we did not dispute that.
Okay.
As it relates to the trial court, on the attorney's fees, he gave half of the attorney's fees. He didn't even give the full amount. He gave half, and I believe that's because he was stating that the minor child was not going to relocate. And so I think under 365103C and the statute, the relocation statute of 366-108F provides the ability for the courts to give attorney's fees. It says nowhere in there that it's the prevailing party. And so we're stating here.
Did the court give any reasoning as to its award of attorney's fees?
Did he give any reasoning? Well, one thing is mom makes $450,000 at that time at her new job, and my client makes $55,000 and pays half the tuition. He didn't state that.
But did the trial court say that?
He stated that he was only awarding one half of the attorney's fees, which was more than reasonable which was reasonable.
Normally, when we review an award of attorney's fees, we review the reason that the trial court awarded them.
I have to admit, I do not know the exact reason for that. I do know, I think he stated he prevailed on, a portion of this case. And so he prevailed on not letting the minor child relocating. There was 2 children, and the other one was allowed. So instead of giving the full amount of attorney's fees, he gave half the attorney's fees. Do you have any other questions on that?
I see none.
As far as the appeal, we're asking to affirm the attorney fee award in the trial court. There is a substantial difference in the amount that each party makes. We're also asking for his attorney's fees in this based on those 2 statutes that I referenced earlier. And we're aware that it is within the discretion of this court. And in considering that discretion, we would like to have this court consider the requesting party's ability to pay such fees. In this case, we had 5 issues. I think they're non-meritorious issues. We had to research 5 separate issues to prepare the appellee brief. We have a father who makes $55,000 as a teacher, and he also is paying for half the private school for 2 children. The other thing to consider is the requesting party's success on appeal. I'm hoping that this court will affirm the lower court's decision, and whether the appeal was taken in good faith and other equitable factors relevant in this case. We contend that we should be the prevailing party on this case. We're unaware of the appellant's true intentions on this, but we do believe that this is a case that the father, the appellee, should be awarded his attorney's fees.
When the argument was made with regard to you seeking attorney's fees, was the difference in the salaries discussed with the court?
We discussed that throughout the hearing, because there was the issue of the private school. She was wanting to move one person to the Briarcrest at one point in Memphis. So there was the issue of finances, plus we were arguing at one point, just prior to that, underemployment. So there were some issues that it was underlying. Whether or not it was specifically addressed, I do not recall at this moment.
But the court was aware of that difference?
Oh, yes. In fact, I don't remember if we did it in that hearing or the other one. We put in her Social Security earnings for several years. So the court was aware. And we had just done they had the 2023 income information. So yes, the court was aware of that. So, in conclusion, what I would just state is that we are asking that this court affirm. We believe the trial court correctly analyzed this case under the statute of the relocation statute of 36-6108. We believe that there is reasons for the attorney's fees and to maintain the attorney's fees in the trial court. Have any questions?
See none. Thank you.
Thank you.
Very briefly, and I really will be. I want the court to know that because my client loves her children, we discussed at the end of the trial, it's in the record, that she was not going to take any action to separate the children, and wanted to know what his ruling would be if she moved within the 50-mile radius. And of course, he said, well, take that up with us later. So I just want you to understand that not separating the children that's what's going to happen, one way or the other. I don't know how she's going to do it, but that's the way it's going to have to be. She's not going to separate these children. And if it means moving closer, then within the 50-mile radius from Dad, then I think that's what she'll have to do. I don't think she can physically continue with what she's been doing at this point. And also, I want to again ask the court, in looking at the facts that the chancellor gave us for his reasonings, and I agree, he went through the statute and talked about each one and did it just the way it's supposed to be, but none of those facts were extraordinary facts which would support separating these children. And that my client has been the primary residential parent for them ever since the divorce, and she has done the majority of the care for them. Dad has been a good dad. There's no question about that. He's done his part. But she's been the primary residential parent, and let me tell the court that, again on the record, in the plan, that she is paying Dad $2,374 in child support. So she's paying the max, plus he's providing insurance. Thank you.
Thank you. Thank you, counsel. We will take this matter under advisement. We will review the record and endeavor to get you an opinion at the earliest possible time.
Thank you, Your Honor.
Thank you. We will stand in recess until the call of the docket.
All rise.
We'll miss you, Judge Golden.
Yes.